dear listeners, and to another insightful episode of International Legal Scholars and Practitioners podcast. I am your host, Dr. Mokhinur, and today we embark on a journey into the realm of big data with an esteemed guest who brings a wealth of knowledge and expertise to our discussion. In the ever-evolving landscape of technology, the intersection of law and data has become increasingly crucial. Today, we have the honor of being joined by Dr. Muhammad Nizam Awang, a distinguished legal scholar and practitioner hailing from the renowned University of Science, Islam, Malaysia. Dr. Muhammad is a thought leader in the field of international law with a specific focus on the legal implications surrounding the vast and intricate of the big data. And throughout this episode, we'll delve into the complexities of big data, exploring its impact on privacy, intellectual property, human rights, and international relations. Dr. Muhammad's extensive experience in academic and practice allows us to navigate through the legal intricacies of this digital age and shedding light on the nuanced legal frameworks required to navigate the challenges posed by the area of big data. Welcome, dear Dr. Muhammad, and we're glad to see you here today with us. Your presence enriches our discussion, and we have eager to delve into the insightful world of big data through your expertise.
It's my pleasure to join your great podcast. I have seen the previous series. Has been interesting topics on your podcast. So thank you so much for the invitation. I'm looking forward to share my thoughts on the subjects that we'll be discussing today.
We also hope that it will be very interesting. Okay, thank you, dear Dr. Muhammad. And we'll start asking you questions which are connected with the field of big data today. Dear Dr. Muhammad, what do you think? How are the international legal frameworks evolving to address the jurisdictional complexities and conflicts arising from the global nature of big data operations?
To start off the discussion, I think when you mentioned about the international legal framework here, it's a complex area because it does not only revolve around the issues of data protection per se, but it will be intertwined with the issues of cybersecurity control, data protection concerns, and of course, we are looking at issues like geopolitics of the data itself. So with regard to the legal framework here of big data operation, because the nature of big data, number one, it involves a large amount of the data set. And the operation of the companies now has gone beyond the territorial jurisdiction of a particular country. So you can see that in most jurisdictions where they have this national data protection law, they have this provision called as extraterritorial effect. That means when the data is processed by a company involving the data subjects of individual belong to a particular country, then you need to have the law that also have an outreach of the data being processed outside their country or outside the region. So at the moment, there is no really binding legal framework when it comes to big data operation. But we do have some, I would say, a soft law guidelines, which has been initiated long time ago in 1980 by the OECD and WTO. They published a guidelines called Guidelines on Protection of Privacy and Transboundary Flow of Personal Data. And another international organization here is APEC, Association Asia Pacific Economic Cooperation, where it is a binding commitment among the member countries, where US is a member and EU is not, interestingly, here. So when it comes to the international legal frameworks here, we see that basically there are three major different approaches to big data. EU always sees regulations of big data is a strong emphasis of the fundamental rights. Fundamental rights because it is very much aligned with the EU's constitution. And then the United States prohibits the parties from restricting cross-border data flows with a limited exception. So US basically has 50 states, so you have the different law among the states. And in the developing economies, like for instance, in Uzbekistan, Kazakhstan, and as well in other regions of Asia, they have also the laws with regard to the big data operations. So different countries have different approach to big data operation. And at the moment, there is really no what we call a binding regulation, as I mentioned to you just now. And as at December 2021, the World Trade Organization has published a statement that that data privacy and data flow, interestingly, is not listed as an issue which has achieved a good convergence in negotiating groups, meaning that there is still a large diffusion or differences or hybridity when it comes to the regulations of the big data. So there remains to be issues of jurisdictional complexity when it comes to who should regulate, how we should regulate, because when the data goes across the border, then there is a question whether the transfer of the data is safe enough to be taken out of the jurisdiction for the processing outside the country or involving individual to be processed outside the country. Yeah.
Okay, Dr. Muhammad, thank you. And it's very interesting that we all know that data protection and cyber law, there is not any borders to regulate with only one law. Okay, and in the context of big data, how are the data sovereignty concerns affecting cross-border data flows, and what legal measures are being implemented to mitigate these challenges today?
When you mentioned about data sovereignty, it's becoming now an important topic for the international legal community. So I would like to start with the famous Schrems II decisions, which has invalidated the data transfer from the EU to the US. So this case is a very important case, not only because it gives impact to the transatlantic data transfer from the EU and US, or from the US to the EU, but it has a very significant global implications. So the decisions has actually give a strong effect to the practice of the data transfer. Number one, because the decision said that there shouldn't be any data transfer unless you can assure that there is a safe transfer of the data flow. What happened in the case was that the US cannot assure, the decision is actually from the EU court, CJEU, Court of Justice of European Union, where it says that if the importing country, in this case the EU, cannot assure there is a safe flow of the data, that means the data flow cannot happen, cannot take place. So if you have that kind of assurance, then only the data flow can happen. So the case also gives us a very important lesson that there must be a kind of like bilateral agreement between the two countries to facilitate the cross-border data flow. Okay, but if there is no agreement, then we can go through with the mechanism of standard contract clause, but it has to be approved by the respective data protection authority, particularly from the exporting countries, in this case from the EU. Or if you do not have the standard contract clause, then there must be a binding corporate rules That means there must be a set of code of ethics among the companies, or among the companies and the government if the transfer of data involve a different kinds of entity, public and private entities. So there must be a sufficient mechanism to assure that. Or otherwise, there must be an adequacy decisions, meaning that the importing country must have a sufficient level of protection to ensure the safe data transfer. So the data sovereignty here really affects the cross-border data flows. Particularly, it is very much related to the issues of data governance, on what data can be transferred across the border, because the treatment of the data, for instance, between personal and non-personal data has to be taken care differently, and it has to be subject to several what we call arrangement or agreements. So what happened in between the EU and US here is actually has given a lot of important concerns, particularly among the data protection authorities, on what can be achieved at international level. So it is quite challenging at this point of time, because not many countries actually is aligned to the EU GDPR. And again, the question here is that whether should we all be aligned to the EU GDPR? So what measure that some countries have taken is that they build the regional or bilateral ties among the countries, rather than simply follow the EU, so that there can be more, regional pact rather than the global pact. So that is what's happening now. On the question on legal measure just now, you see that there is an emerging rise of data localization trend among the countries. But for instance, in India, they introduced data localization, meaning that the company or the data controller or data processor who process the data, if they want to use the individual's data subjects data from India, for instance, or from Indian companies, they have to set up a computing infrastructure in that particular country. So you can imagine that somehow it is actually for the interest of protecting the data of the people, the data of the companies, even more when the data involve a very sensitive matters like public or national security, or banking or financial or biometric data, for instance. So India has done that, but of course it has some counterproductive effect as well, particularly for the business, because it's not cost effective. It can increase cost of regulatory compliance, and somehow it would be quite unattractive for the investment of the foreign companies coming into the country. But that's somehow what's happening in some countries. Yeah. But apart from that, the legal measure that we can take from the context of data sovereignty here, we need to push for more agreement between the countries, particularly in pushing for more bilateral agreements, so that you have what we call mutual agreement between the countries, that they can accept each other's data transfer standard, or what we call in the context of data protection as data interoperability standard. So when you have that data interoperability standard, meaning that the data is stored in a particular format or standard or protocol, can be transferred to another format, which is almost equivalent to the importing or exporting country. And the final measure that we can also think of here is there must be a reform of the national data protection legislations. Let's say from the EU, for instance, in the Malaysian perspective, we are not able to make our law adequate to the EU, because there are some provisions which are not introduced in our data protection legislation yet. For instance, on privacy by design or security by design, where in some circumstances you need to have a data protection impact assessment. So now when it comes to the digital technologies like AI, you have the AI Act in the EU. And EU has its own approach. For instance, they categorize a certain risk of technologies presented by the AI. But in our region, ASEAN region, for instance, we do not follow the EU style of approach because of, I think, in Asia, basically, there is the countries are more diverse in terms of cultures, in terms of religious sensitivities, for instance. So we cannot simply follow EU because there are some differences when it comes to the approach to the technology and also to the law. And when it comes to the reform of the data protection legislations, not only we should provide a better or greater protection for the data subjects. What is important is that we have to make sure that we have enough legal remedies in the case of the data breach. In many circumstances, when it has data breach notification, for instance, there are countries where data breach notification is not made mandatory. But there are some countries which is made mandatory. So how do we actually synchronize or align the law of different data protection legislations here is to make sure that we have what we call a minimum legal baseline so that the standard can be achieved across the various data protection legislations. Yeah.
Thank you very much, dear Dr. Muhammad. It's very interesting about the cross-border data flows and the challenges which are becoming more serious and affecting to the international corporations and organizations also. And what do you think? What legal mechanisms exist for resolving disputes related to the international transfer of big data, particularly when conflicting data protection laws are in play?
Thank you so much for the question. I think in follow-up to the question, the countries must be able to see what is the critical risk presented by big data. In this context, as I mentioned in the beginning of my speech just now, we need to see the issues or the conflicts around big data around at least 3-4 lenses here. Number one, with regard to the cybersecurity control. So different countries have different privacy or different big data control. And for AI, for instance, because it involves big data, where huge amount of the data will be used for the AI applications, we need to see what is the risk in the AI. So when you see there is intersection between cybersecurity and AI and then data protection, we need to ensure there is what we call what risk actually becomes critical to that particular country or to that particular region. With regard to the legal mechanism here, as I mentioned just now, we can go through the bilateral ties of between the countries so that they can achieve a mutual understanding about the safe cross-border data flow. There must be an agreement between the governments, or in fact, if it involves between the private entities, there must have a standard contract clause so that we can ensure that the data, for instance, the national data of the individual's data from Uzbek, for instance, is protected when it is processed outside the country. So the agreement is a binding legal document that would what we call regulate the activities of the data processing.
Okay, thank you very much. And how do different countries approach the regulation of algorithms and artificial intelligence within the scope of big data, and what legal implications does this pose for businesses operating globally?
Well, that's a good question, because whenever it comes to regulation of algorithm and AI, it does not only sit within the scope of data protection law. So it can become very sectoral depending on the types of the data, because of the existing regulations now. For instance, in the banking sector, it is very highly regulated sector. So when you have like the emerging initiatives like open banking or digital banking, um, there must be a proper legal framework to regulate the data being transferred outside the country, or in fact across different sectors. How the approaches here would be quite different from one countries to another. Is becoming more complicated because at the moment, many initiatives are being carried out still in the form of soft law or codes of practice, because this is a new emerging issues particularly. So if you look at the regulation of algorithm and AI and big data here, the main reference is always the data protection law, because the main concern when it comes to the regulation of algorithm basically involve around the issues of transparency of the algorithm, or accountability of the data controller involved in the data processing, or also the issues when it comes to the fairness, how far the data will actually affect the individuals or the entities involved here. So the question that we always be asking is that, does AI application is based on sufficient legal foundation? If yes, then what would be the possible law that you'll be using here? For instance, if you're talking about accountability, accountability requires transparency or um, openness of the entities involved, data controller here, to disclose the relevant information to the data subjects. How much information should be disclosed to the data subjects? And do AI process comply with data protection law? Nowadays, Dr. Mokhinur, we're talking a lot about generative AI, right? We have many cases, particularly in the EU and in the US, because the data protection authorities are very active. They are supervising closely the conduct of the big tech giants, the Google, Facebook, Twitter, and Instagram. So there is a question whether the practice has complied with the data protection law, because big data is not like it's not like a normal or singular data. When you have huge amount of data, it's very actually difficult to see how the practice is compliant with the data protection law. Whether you use the data is actually for the purpose that you have told the data subjects before. For instance, when you talk about Facebook, for instance, here, Facebook harvested a lot of individuals' consumer data from our interaction on social media, on the platform. So the question here is that, are we adequately informed by the Facebook in their privacy notice that the data is only used for a specific purpose? There have been so many incidents, for instance, if you go on online shopping, on how big data has been harvested, where Amazon, for instance, can predict the way you're shopping. I mean, some people, because of their predictive online behavior shopping, the price charged to them is different from people. So that is actually issues of pricing discrimination, because based on the algorithm, they can actually predict what kind of items that you bought online, the price that you are able to pay for the items. And at the same time, the question here that when you see the country's approach, who or which body actually exercise the regulatory oversight, or who has the responsibility to ensure that they use the responsible AI products, services, and systems? So for some advanced country, there is a dedicated, strong regulatory agency to monitor the activities. But for some other countries, they are still struggling to put AI under which system. The reason being because AI not being a data protection concern only, but it is actually a competition among the companies in using algorithm. So some companies may use algorithm to discriminate other companies. So the anti-competitive behavior here is a concern when it comes to the country's approach. Some countries like in the US, they have a very strong antitrust law where the Federal Trade Commission have a big or wide regulatory oversight over the big tech corporations. But in some countries, particularly in Asia, some what we call data protection authorities are not independent. They are still falling under the government umbrella. So you can imagine that when it comes to the exercise of their regulatory power and jurisdictions, they are quite limited in that sense. It's very difficult for them to, so-called punish the big tech corporations because they are not independent enough to exercise and their power is very limited. That's what happened in some countries like Indonesia, like India, and like Malaysia as well. So maybe that there are some similarities in some in the context of Uzbekistan as well. So if the data protection authority has enough power to regulate the big data, that means they must involve concerns, they must address concerns with relation to data protection, cybersecurity, and also competition. So that requires, in the at least in the Malaysian context, to get involved several regulatory agencies where you have like a super agency or super authority that can reach out to different aspects or different implications of the big data usage.
Thank you very much for your answer. And the next question will be the responsibility of states or international organizations. What steps are international organizations taking to harmonize data protection and privacy laws to facilitate the responsible use of big data on a global scale?
Interesting question, because now there is a movement towards the establishment of the first international AI treaty. At the international level, you can see that different international organizations, either within the United Nations, within the UN, or outside the UN, they are aggressively pushing for different kind of initiative. For instance, like UNESCO, we know that they do not pass a binding international law, but they introduce soft law in the forms of code of ethics of AI. Ethical AI is a big thing now. So apart from the legally binding AI, but ethical AI is important, particularly to incorporate responsible and safe use of AI. Because at the end of the day, when the big data is harvested from the individuals for many kind of purpose, either commercial or non-commercial, it must not contradict to the fundamental rights of the individuals. At the international level, other than UNESCO, you have OECD. OECD, is an organization comprising the so-called rich countries. They set what we call the international standards, but developing economies are not quite involved in that. So for the advanced economies, they are quite advanced because they are the technology leaders. But for us in the developing economies, we are quite concerned because we are more technology followers. So organizations like APEC, for instance, in the context of ASEAN, you have ASEAN, where they have already produced different numbers of guidelines on data protection, on cross-border data flow, and hopefully by the end of this month, because it has been out last year, that they're expecting to come up with the ASEAN ethical AI guidelines by the end of January, somewhere around this month. So we would like to see how the ethical guidelines here is proposed from the context of ASEAN, rather than we are being dominated by, by only some countries. Because at the moment, there are only three regulatory regimes in the world: US, EU, and regimes. US, EU, and Chinese regimes. So they are quite dominant when it comes to the approach to regulatory regimes. So I think when it comes to the international organizations here, what we should actually do is actually to come up with a soft law or codes of practice, so that we can exchange the best practices among the countries, number one. Number two, we need to create more use cases. Like in the context of some countries, even though we allow the transfer of the data beyond the borders or across the borders, we cannot simply apply to various or all situations. As a start, we should actually come up with the specific use cases. For instance, if there is a big national project like for digital identity, because digital identity is where everyone, individuals in the country, including particularly for the citizens, they will put all the data in one platform, so that the security of data is more secured and guaranteed. And the data also can be used for other purposes, but we have to come up with a clear guidance on what data should be used for data transfer and what should not be used at this point of time. We cannot open that, because the issue here, Dr. Mokhinur, when it comes to Asian countries particularly, we do not have a strong enforcement mechanism. That's always a problem. So we can have a good, nice data protection law or the cybersecurity law, but when there is any issues of data breach, then you must have an effective enforcement mechanism. So international organizations here play a role to guide particularly these countries to learn from the more experienced country and how they can emulate the practice into their own countries. And there must be, of course, cooperations between countries to promote a safe and responsible cross-border data flow.
Thank you, Dr. Muhammad. And I think I totally agree with you that countries should work as a one big team to control the big data around the world, like a chain, and all countries are connected to this. Okay, and in the realm of big data, what are the emerging legal considerations and challenges surrounding data localization requirements and their impact on multinational corporations?
Okay. The emerging challenges here is to ensure that there is a safe cross-border data flow, whether the data protection law is comprehensive enough to address the issue of a safe transfer. So here it comes back to the issue of data governance and data protection as a whole, and of course the issues regarding the cyber security. When you have a cross-border data flow, there will be questions about how the current law will be able to facilitate. We cannot stop the activities from happening. What happened is that when you had decisions of Schrems 2, it has stopped the US companies from getting the data from the EU to be transferred to the US. And that has affected the businesses as well, because there is not enough they call data privacy platform to transfer the data. So the emerging patterns here is to see the interaction, as I mentioned earlier, between the cybersecurity and also data protection together in place with the data governance. We cannot always see this issue only on data protection per se, but we have to see the issue as a whole, where we must be able to see when you have the big data, it's actually more exposed to cybersecurity risk. Particularly, the malicious hacker, for instance, is more interested to attack the hardware, software, or the vendor, the suppliers of the data. So it's very important for the countries to see the intersection between and to present a comprehensive legal framework, at least for that particular country national laws. Data localization here, as I mentioned earlier, is quite counterproductive to the cross-border data flow, because it restricts. You can have restriction, but unnecessary restriction would actually delimit the transaction, delimit the digital economy to grow and expand. So like you have before e-commerce, now a digital commerce, which is actually more robust and require the countries to have more open economies. But at the same time, they must have a proper guardrails, meaning that the entities, data processor, data controller, must be able to understand the parameter on what they do, what they can do, and what they cannot do. So data localization effect is actually not good. But if they were to be implemented, they must have a certain parameter what the countries can actually restrict to, what country can restrict when it comes to the cross-border data flow.
Thank you very much. And how are legal frameworks adapting to address the ethical implications of big data, such as algorithmic bias and discrimination, especially in the industries like finance and healthcare today?
In the context of bias and discrimination, in the two industries that you mentioned just now, it is highly regulated industries because it involves sensitive personal data. In the context of finance, for instance, there is an emerging trend of open banking or digital banking, where the banks now operates beyond the conventional operation. So it's supposed basically serve the function to the undeserved or undeserving community, like the poor or who does not have, reach out to the physical banking facilities. So whenever it comes to issues of bias here, the banks particularly has to be subject to a code of practice, like the same thing in the context of healthcare. There has to be subject to the codes of practice on how to handle the data according to, for instance, in the banking and finance, you have a very strict regulation about the credit scoring systems. Algorithm is good actually to help us whether we will be able to apply for the loan. But when the algorithmic system or outcome differentiate the people or the data subjects on the basis of race or ethnic or sex or color, for instance, so that is actually discrimination to the people. We have many examples where in some countries where people are discriminated unfairly on the ground they have or they belong to different colors of ethnic. So that kind of bias is not acceptable. Well, in the context of AI, you cannot AI to be perfectly neutral, because to produce a good AI, it depends on whether you have a good data. So if you have a good data quality, that means you can have a proper or a more comprehensive fair outcome of the data. Again, in the context of healthcare as well, before you have in the context of Internet of Things, where tracking device, IoT, Internet of Things, the issues of ethical use of the tracking device has been questioned because that actually can create algorithm by using of the tracking device by looking at the behavioral patterns of the people, right? Or maybe in the context of where you have the smart home device. So all these applications would contain bias and discrimination. But if it affects the what we call the fundamental rights of the people, then we have to carry out the data impact assessment so that that would not affect the fundamental rights of the data subjects. So in the context of data protection here, algorithm must not be discriminatory. If it is discriminatory, then the Data Protection Authority should ban the practice. I still can recall, it's quite a recent incident actually in the US where they have banned this NGO, Right Aid, for taking a face surveillance openly without the consent of the individual data subjects. So the FTC, the Federal Trade Commission, has banned the organization from doing so, from taking the face surveillance for 5 years. So this is a very important measure to ensure that not only it is unethical, but it can also be illegal to the extent of it affects the fundamental rights of the individuals. In the context of finance just now, that if it affects the financial opportunities or access of individual to get loan or to get any access to other facilities, sometimes it's not only about the financial, but when the financial is affecting the other opportunities access because of the finance, that can be discriminatory if the credit scoring system is unfair to the individuals. So we're gonna have like quite what we call emerging trends when it comes to bias and discrimination, but that's how we manage that the bias and discrimination does not affect the fundamental rights of individual. So that is, we must know that where is the acceptable parameter, what bias can be acceptable by the law and by the ethics.
Thank you for answer. And what do you think? What legal mechanisms exist to ensure transparency and accountability in the collection and use of big data, particularly when dealing with complex machine learning algorithms?
Okay, thank you for the question. This question is not only a legal question, but also a technical questions as well. So meaning that when you talk about transparency, it relates to disclosure of the data logics and how does it apply to algorithm and data set. So here when it involves big data and AI, you must ensure that there must be quality data set, quality standards of the data set, and it must be supported by adequate legal framework. So when talking about transparency here of big data, we are referring to the automated decision making. Whether the data protection can give the sufficient safeguard to ensure that the automated decision making is actually protecting or ensuring the fundamental rights of the people. With regard to accountability, I did mention earlier about the responsibility of the data controller or data processor to ensure that the data processing activities is done in accordance with the data protection principle. We have 7 or 8 data protection principle here that the data must be processed fairly, in fair and transparent manner. It must be carried out in what we call for the particular purpose which is actually specified by the data controller. So here, when it comes to accountability, we need to ensure that we have the privacy by design or privacy by default in place. And under circumstances, you have to carry out data protection impact assessment, particularly when it affects a huge number of people. And apart from that, there must be a clear rule. For instance, when it comes to accountability, because algorithm is such a very complex technical computer science kind of techniques. So there must be a way to explain to the data subjects on the outcome of the algorithm, even though they do not understand, they do not need to understand the technical integrity of the algorithm, but they must know what their algorithm or what data they have been, what data the data processor have used for the purpose of algorithm. At least they must know the purpose of the algorithm is used for. That's the thing that we have to take care of. And another thing is that I would like to add another point here, apart from the accountability and transparency, we have to ensure the safety and robustness of the AI systems. So that means there must, when you say safety of AI or AI safety, you must make sure that the whole set of data lifecycle must be secure, from the design to the development and implementation or application of the AI. We cannot always see at the end of the data lifecycle, which is on the downstream, but we have to see from the upstream, midstream, and also downstream, so that we can have a proper monitoring of the AI applications. OECD actually has published, OECD Council has published a recommendation on AI. They say the AI system should be robust, secure, and safe throughout their life cycle, in the condition of the normal use, foreseeable use, or misuse. And it must not pose unreasonable safety risk to the human. Therefore, AI actors should ensure that the system must be traceable, that includes the data set, process, and also decisions. So all in all, we have to make sure the AI system must be appropriate and also safe and also resilient to the use of the public. And another thing that I think related to the previous point, we must execute impact assessment of the AI. That means AI impact assessment, as similar to privacy impact assessment, must be carried out for a certain use of AI.
Thank you, dear Dr. Muhammad. Yes, I agree with you that algorithmic mechanisms are for IT producers, for IT technologies. And regarding to our big data, how do international data protection laws accommodate the growing trend of collaborative data sharing among businesses and research institutions? And what challenges does this present today?
Thank you for the question. For this part, I think what we need to look into is that some critical component needs to be addressed. Number one is there must be a privacy by design or by default approach to the use of AI for the various purpose involving different actors. Number two, there must be a clear data sharing agreements. For instance, if you are sharing the data across different government agencies, they must have a clear the do's and the don'ts, particularly when it comes to the purpose limitation of the data minimization, where the data is only used for a specific purpose and not for other purpose. And that purpose must be informed to the data subjects, because in the age of AI, where you have algorithm will be very useful for many purpose. If you have a good training data set, that means there will be misuse is open for misuse of the data. So harmonization at this point of time is very important. Particularly, we are talking about data across borders. So the data protection law, the countries should make sure that they have the next point that I want to mention here is that on data interoperability standard, or some countries call it right to data portability. Because in some countries, not all entities are subject to data protection. In some countries, they do not exempt the governments from, they exempt the government from the personal data protection. So the governments are not subject to under the data protection law. But there must be other mechanism where they have to be subject to ensure the safety of the data, because most of the personal data is in the hands of the government. So data interoperability standards is very important across the organizations, across the region, across the countries, so that there will be a sufficient and safe cross-border data flow. Apart from that, the government or the concern that the international organization must take into account for harmonization is that in terms of the security and privacy standards. So cybersecurity standard and privacy standards and also data governance must be integrated. We cannot see these three areas separately. So that would be the way forward. And of course, when it involves AI, the best way is to understand what is the most commonly used AI in that particular region. The EU, the US might have different priorities than the countries in Asia. So we must set up what is the legal priorities that we need to address when it comes to the use of AI, so that we can develop the regulations of data protection and privacy more organically to respond to the risk of the AI used at international level or beyond borders.
Thank you for your answer. And my next question will be very sensitive, big data protection and breach of the information. And what are the legal ramifications and potential liabilities for companies in the event of a cross-border data breaching involving sensitive big data? And how are these issues being addressed at an international level today?
The question is very important, because when you have the cross-border data flow, then we can see there can be more cases on the cross-border data breach. So in this event, I would like to come back to the basic of the data protection law, which is on the data breach notification law. So in this regard, different countries have different rules and standards and approaches to data breach notifications. Some countries have a broad law, comprehensive law to address data breach notification across the sectors. Some countries have a very specific law which address, for instance, reporting incidents for financial data leakage, for health care information being leaked out. For instance, when it comes to the use of a particular interconnected device, IoT device. If we can take some examples here. The EU is very what we call comprehensive in this. They have omnibus law that address data breach notification to apply to data processor and data controller, and they have also specific data breach for specific sectors. The US, they prefer to come up with breach notification rules for incidents in the medical, financial, and other types of data. So different countries, I would say, have a different rules for that. But at the end of the day, when it comes to cyber data breach involving big data, what we need to know is that what caused the algorithmic harm. We need to know how algorithmic harm is determined, because algorithm can be good and also can be harmful for the data subjects. If you're talking about the data breach notification, in fact, if you want to determine what constitute data breach, is already different from one country to another. Like in the US, for instance, they define data breach as unauthorized or illegal acquisition of personal information. But in some other jurisdictions, in order to constitute the data breach, you have to establish not only on the unauthorized access, but also in combination with other activities. In Singapore, for instance, you must prove the harm or the risk of the harm caused by the breach. So there are different legal implications here. Different countries have different way of proving a data breach. But at the end of the day, the countries must incorporate a risk standard. That means if you want to say it is a data breach, that means you must make sure that there must be a necessary legal action taken against the company for the data breach. So harm can be a important threshold to trigger for the commission of data breach. So if this happened, then the company should be subject to heavy fines or any kinds of relevant penalties. But again, it comes back to different law have different fines, different countries have different forms of enforcement mechanism. So we cannot, of course, in Asia benchmark ourselves against EU because it's totally like a different level of enforcement. But we can start somewhere so that the data must be protected sufficiently according to the risk presented to the countries, particularly like we have seen in the context of Malaysia, for instance, there's been several cases of financial data leakage coming from the banks, and the allegation that the data is leaked when it comes to biometric data. But the issue here is whether there is a data breach notification law, because we need to make sure that the incident would not recur, would not repeat in the future. So a strict action, stringent penalties must be imposed against the company so that the companies must make sure that the data is secured in their systems. And if it is exposed to the hacker, for instance, then you have to do the data breach notification rule. Of course, this one depends on the data protection authorities to do. Some would require to do that in the name of public interest. But in other situations, we need also to know what is the impact of the data breach to the countries. So when you talk about the legal implications and potential liabilities, just now, I would say, in short, different countries have different rules. But at the end of the day, we have to make sure that the data is protected. And if there is any breach, then there must be a revision to enhance the protection of individuals' data under the data protection law and also cybersecurity law.
Thank you very much for your answer, dear Dr. Muhammad. And as we wrap up this engaging conversation, I want to extend my heartfelt gratitude to Dr. Muhammad Nizam for sharing his profound insights on the legal landscape of big data. The complexities discussed today remind us of the pressing need for the dynamic and adaptable legal framework to navigate the ever-evolving challenges in our digital world. And a special thanks to the University of Science Islam Malaysia for supporting this episode and facilitating our conversation with Dr. Muhammad. Their commitment to fostering intellectual discourse in the fields of law is truly commendable. Thanks a lot for sharing your knowledge and time today, dear Dr. Muhammad.
Thank you so much, Dr. Mokhinur, for an interesting discussion. And I'm looking forward to have more conversation on the subject matter, and hopefully there will be more interactive session in the future around the issues of big data and the law.
Yes, we will think about that, and we'll continue our teamwork with you. To our listeners, and thank you for joining us today on the journey into the depths of international law and big data. Your curiosity fills us with exploration of these crucial topics. And if you enjoyed today's episode, don't forget to subscribe, rate, and leave your comment. Your feedback is invaluable. And stay tuned for more rewriting conversations with international legal scholars and practitioners. Until next time, this is Dr. Mokhinur Bahramova, and I'm signing off. Remember that pursuit of knowledge knows no borders. Thank you. Bye.
Bye.